just want to confirm again if everyone. Okay. Please, can you, when you join the meeting, please can you mute your mic? I can hear some background noise. Okay. Thank you. Okay, so first on our agenda, I don't know if he's here yet, but we have a special guest in our midst, Mr. Confidence Amuda, a data privacy and information security expert from England. I don't know if he's here. It's Mr. Confidence. Please, if you can hear me, can you signify? Okay. He's not here yet, so we'll just move right on to our agenda for today. So we have three seasoned speakers who will be speaking to us today, like on the topic I mentioned, and I want to do a brief introduction on them. Starting from the first, we have Winnie Ingige. Winnie is an experienced privacy and data protection specialist. She holds a law degree, and she's also a certified information privacy manager and a member of the International Association of Privacy Professionals. She has expertise in incident response and breach handling, data protection compliance, audits, training and awareness programs, data protection impacts assessment, and implementing effective privacy controls to protect personal data. Winnie will be joining us as our first speaker for today. And our second speaker for today, we have Mr. Kelechi Atama, who is a partner at Lexeter's LLP, where he heads the corporate and commercial law practice units. He's also experienced in data privacy and security, and he's a certified information privacy professional. Our third speaker for today is Miss Adeshola Obutimehi. I'm so sorry if I mispronounced that. She's a cybersecurity professional with experience as a GRC analyst and founder of Cyber Patron Network. Cyber Patron Network is a cybersecurity network where tech talents are mentored, trained, and outsourced. And she has actively contributed to compliance improvements and security system management for companies and individuals interested in creating cybersecurity awareness and training for digital and non-digital literacy. Okay, so please, can you please, like I mentioned before, when you join the meeting, please mute your mic and put off your video so that you won't distract the meeting as it's going on. Okay, so let's get straight into it. Our first speaker for today is Miss Winnie Ingige. I don't know if she's here already. And also, I would like to mention, for the speakers, please would not want the slides to be shared. Want you to connect with our speakers. So this the slides and the screens of the speakers will be shared to this meeting. However, the slides would and the recording will be sent to everyone who participated and who registered for this webinar. I just want to let you know that. Okay, for our first speaker, I don't think she's here yet, so I can see Kelechi Atama here, who is the partner at Lexeter's LLP. So Mr. Kelechi, please, would like to give you the platform.
Hello, Chama. Good morning. Thank you to you and your team for the opportunity to be part of this conversation. I'm not sure I understood what you said about sharing the slides. Are you suggesting that we should not share the screen while we're speaking?
Yes. Share your video. I'd like to share the screen because we want people to be more focused on what you're than bends on
Okay,
copying.
okay, that's fine. Just give me a minute. Let me do that. I believe you can see my screen now.
Yes, but just yeah, there's no need for just you can just leave it this way. You don't have to like continue sharing slides. Just leave it this way.
Okay, don't worry. So, good morning, everyone. I'm supposed to be the second speaker. My expectation was that maybe the first speaker would have laid the foundation for this conversation, but I will just stick to the topic that has been assigned to me, which is e-consent framework and compliance requirements. So generally, data protection in Nigeria, is, for want of a better word, is relatively new compared to, what you see in Europe under the GDPR. But then we have also progressed in terms of legislation and practice. So far, Nigeria, we have a couple of legal framework that have been devised, to regulate this area of our, well, I said legal system. So we have the primary legislation, which is our constitution. Some would say that, the privacy rights under the constitution is not the same as the data privacy and protection rights that you have under the data protection laws. But whether or not this is true is a matter of argument anyway. But I would say that, your right to privacy is founded in the Constitution, such that every other legislation that we have derive their existence from Section 37 of the Constitution. But that's not the crux of this conversation, so I will not really delve much into it. So we have the Data Protection Regulation of 2019. The regulation was, or let me say, is a bit sketchy, being that it was something that was done to manage the situation, pending when a proper legislation comes up. And then we also had or have the NDPR implementation framework. The framework is designed to guide the application of the regulation. So it tells you how you're going to do your audits, how you're going to do certain things to make sure that you comply with the regulation. So we also have the Nigerian Data Protection Act of 2023, and currently a draft general application and implementation directive. The directive hasn't come in place, it's still a traveling draft that is being reviewed. So we expect that when it comes on, then it's going to provide a robust direction on the application of the NDPA. So it's similar to the implementation framework of the NDPR. So it provides some sort of guidelines on how the relevant provisions of the NDPA are supposed to be in practice. Then the Nigerian Data Protection Commission is the institution that regulates data protection in Nigeria. Their job is to ensure that you and I enjoy the rights that we have under the relevant legislations. They also ensure that various data controllers and data protectors, these companies, are compliant in their daily operations, such that when they process the data, the personal data of their customers or employees or whoever comes in contact with maybe digital space or their offices, have their rights well protected in such a way that their data will not be mismanaged. So the general understanding of consent.
How is it going?
Sorry, is that a question?
The table call session is going on.
Oh, sorry, please just carry on. I think
The
someone
session
just.
is going on.
Okay. So the general understanding of consent. So some will say, what does this consent mean? When you visit someone's visit the website of, say, Zenith Bank, for instance, the website is designed to capture certain information about you. For instance, it takes record of, say, your IP address, which gives the owners of the website or the managers of the website, an idea of maybe your location. They can use your IP address to, confirm your location or who you are or the kind of device you use to check their website.
So they have not
If
done
you
that.
log into your app, for instance, maybe your banking app, the managers of the bank.
No, we need to get the survey so that, okay. So you paid to.
Yes, I'm distracted. Can you just mute everyone?
Mute these people. So sorry. These people
Okay.
talking in the background.
All right. So when you log into an app, for instance, the managers of that app have a way of getting information about maybe your email address or, the time you logged in, the kind of transactions you did and all that. So, but the law now requires that before certain information can be obtained from you and processed for certain purposes, that your consent has to be obtained. So if you don't give your consent to the processing of your data, in some situations, the processing of that data would be regarded as illegal processing of your data. There are other exceptions anyway, where your consent may not be needed to process your data. But then what does consent entail? The law requires that your consent has to be freely given. You can't be coerced into giving your consent. It needs to be something that you decide on your own to give. The consent has to be specific in the sense that it has to be geared towards a particular purpose. You don't just collect someone's consent and then the person is not aware of, doesn't know what you want to use the consent for. So it has to be specific to a particular thing. Oh, I'm giving my consent to you to book a flight for me or to book a hotel for me. It has to be specific to a particular purpose. Then the data subject who is giving the consent has to be well informed about what he's consenting to. So if you visited someone's website and you're looking at maybe you see their privacy policy, if you take your time, of course, many people don't read the privacy policy, just click yes and then you move on. But if you take your time to look at the privacy policy, you will see that there are information concerning the use of your data. They can tell you they're using your data to process your transactions with them, or they use it for marketing purposes to direct certain marketing materials to you, or to send you updates on their services, and many other things. So the essence of that privacy policy is that it gives you the information that you need to have before you give your consent to the processing of your data. Then the consent has to be unambiguous. It's not, you don't have to, as a data controller, you don't have to be, to guess whether this person has consented or not. It has to be unambiguous, such that, yes, if you are called upon tomorrow to prove that this person, the data subject consented to the use of his or her data, it is going to be clear that this consent was well given and it was freely given by the data subject. Then the consent has to be unbundled. If you visit some websites, you will see that there are specific, so many things that they do. You know, sometimes they want to use your data to, for instance, to send you marketing materials or market their products to you, or maybe let's say it's a bank to use your data to open an account for you. Now, they're not supposed to model up all these things, into one item, such that when you give your consent to the use of your data to everything without even knowing. No, the way it is supposed to be is that you're giving your consent to a particular purpose. We've mentioned before that it has to be specific to a particular purpose. So for you as a data controller who is obtaining the consent of a data subject, you need to be sure that these purposes are not, bundled up into one item. So you need to be able to break them out so that it is clear to the data subject that, oh, I'm consenting to A, I'm consenting to B, I'm consenting to C. Then it has to be clear and in plain language. The consent request form has to be in a very plain language. If, for instance, you have a child, you're selling products that are meant for kids. So that kids, let me call them minors patronize your website. You are required to make your consent request form in a language that children will understand. It's not something that you use job-breaking words to design your form such that an adult will understand it, but a child will not understand it. Meanwhile, the intention or the original intention is that your site would be patronized by kids. Do you understand? So if you look at this place, this sums up the whole the summary of the consent requirement, the understanding of what consent is. It's an indication of the wishes of the data subject by which he or she, through a statement or a clear affirmative action, signifies agreement to the processing of his or her personal data. So if you look at section 26 of the Nigerian Data Protection Act, it covers everything that you need to know about, consent. Then paragraph 5.1 of the NDPR implementation framework, as well as article 7 of the GDPR. So there are other things, the other principles around, consent. I've talked about, the data subject being well informed of the reason for seeking his consent and then what he's consenting to. If section 27 of the NDPR of the NDPA, makes a clear provision on this. So the method of obtaining consent has to be transparent. So what it means is that the privacy policy has to be explicit. It has to be clear. It should clearly state, amongst other things, the type of personal data collected by the data controller, how the personal data is going to be processed, who is processing the personal data. If you're transferring the data, across the border, you need to mention it and who you're transferring it to and for what purpose. And then, if you should also have a retention policy. So the data subject needs to know, how long are you going to hold my data? Then, if the data, so the whole essence is that if it is not necessary for you to, to collect a particular data, then you shouldn't collect it. If you can complete your transactions with data subject without necessarily collecting certain kinds of data, you shouldn't collect it, because it's going to be a lot of burden on you, and you may end up collecting even data that is, very sensitive, that you should not ordinarily have. So consent should be affirmative. So when you go to certain websites, when they want to obtain your consent, you will see that, they bring out something like a box for you to tick. So sometimes you see that the box for you, the where you have to click yes has already been pre-ticked, even without your, doing anything. So that is a very wrong way of obtaining consent. Come on. So it is a very wrong way of obtaining consent, because what it means is that you have already decided for the the data subject on what to do. You've already decided to click yes for him or her, when the person has not even made a decision for himself. So the proper way to design your consent request form or consent request platform is that the boxes where you need your data subject to decide whether or not to give his or her consent has to be empty, such that the person comes up and says, okay, I want to consent to this. The person clicks on it. But if it is pre-ticked, then that consent cannot be said to have been freely given. It can't be said to be the affirmative action of the data subject. Then no bundled consent. We've talked about that. There has to be consent for different types of personal data uses. Then we are still going to discuss this, but let me just mention it here. A data subject has the right to withdraw his consent at any time. And when do you inform the data subject about this right? At the point of obtaining the consent, the data subject needs to know that he has a right to withdraw the consent. He has a right to also request that consent be modified or be changed, for certain kinds of uses. So, but we'll still see that in subsequent slides. So when is the consent of the data subject required? There are, first of all, let me say that there are various grounds on which personal data may be processed. It can be for performance of your contract. It can be for compliance with legal obligation. If you're employed, you know that your employer already has your personal data. So even without your consent, it's going to use your data for certain things, maybe to file your tax returns to your payee to the relevant tax authority, or to for your HMO, you can send your data to your health management organization to register you for the HMO or office HMO. So these are various grounds, but here we're discussing consent because it's in fact it is, let me say, it stands out because it is the only ground that requires the active participation of the data subject. So the consent of the data subject is specifically required for the following processing activities. So we've talked about direct marketing before, although in passing. So, some of the emails you get from various companies, say banks, insurance companies, maybe Facebook, and all those organizations, they are sending marketing materials to you, as for, advertisement, to ask you to come and buy this, come and subscribe to this. Before such organizations can send you such direct marketing materials, they need to obtain your consent. So you may have been receiving it without knowing that you had consented to it. You may have visited a website and then they bring out, something pops up and you click without reading the entire policy, maybe a privacy policy. You just click yes because you're in a hurry to complete your transaction. So, and then the following day you start receiving emails from the organizations asking you to come and subscribe to a particular service or come and buy this product from us. So what it means is that you would have consented to it at some point. Otherwise, that personalized advert to you is illegal, is wrong. Now, this does not apply in all circumstances. If, for instance, you buy a product from Jumia for once, and subsequently you start receiving emails, marketing emails from them, they are well within the provisions of the law to make such direct marketing to you. The reason is that the law allows them to use your data to advertise their products to you, but there are exceptions. If Jumia, for instance, has to send you those emails, it has to be for one, you need to have consented to, You need to have done a previous transaction with them. That is one. Then the products they are marketing to you has to be their own products. They're not going to market a product or say something for maybe for Konga or for Amazon to you. It has to be something that they sell. So the other point is that the emails has to be for what's it called? For promotional purposes, for advertisement purposes. It can be for something else. So because the whole idea is that when you give initial consent, what you consented for was for their products. You needed to do some transactions with them. So they can't be selling putting up marketing materials that are not related to what they sell to you. Then processing of sensitive personal data. There are certain kinds of data that are regarded as sensitive. The sexual orientation of a data subject of an individual is not the same, doesn't rank with at the same level with say his or her email address. So things like the sexual orientation of someone, race, ethnicity, health, or genetics require the explicit consent of the data subject. So if, for instance, when compared to ordinary data like an email address or phone number that can be used to identify someone, if you require consent in certain transactions, for you to be able to process that kind of data, you can imagine what you require for a sensitive personal data. So here, the law requires that you obtain the explicit consent of that person. It has to be, in my opinion, it has to be in writing and it has to be clear that the person is giving his consent. It's not something that you say, oh, this consent was, I think he said it, I think he agreed or not. No, it has to be clear, very, very clear that this person gave his consent. And then the purpose for which the personal data is being processed has to be, well defined. Then there are circumstances where you obtain consent for a particular purpose, and then subsequently you decide that, oh, we need to use this guy's personal data for something else. You don't have to do that until you have obtained the further consent of the data subject to use his personal data for that subsequent purpose. Then processing the personal data of a minor and persons with legal capacity, without legal capacity, maybe people that are of unsound mind, when they are not lucid and all that, or minors, the consent of the parents or the legal guardian is required. Then before the data controller makes a decision based solely on automated processing, which produces legal effects concerning or significantly affecting the data subject. Sometimes when you visit a particular website, maybe you search for a product online, and then subsequently you start receiving, maybe you log into Facebook, you start seeing products of similar, adverts from different vendors on similar products. You wanted to buy a car, and then you check Gigi, and then you go online, you go to Facebook, and you're seeing cars from other vendors on Facebook. So it's called profiling. These things are automated. So you just visit the website, and then they have a way of collecting your data, and then through some kind of algorithm, they are able to decide what your interests are, and then they channel the products that align with your interest to you, so that once you go online, anywhere you go online, you'll be seeing the kind of product. So your consent is actually needed before a data controller can have this kind of processing on your data. Before personal data is processed in a country which is not in the wide list of countries published by the NDPC, this is called cross-border data transfer or processing. There are countries that have been designated as white list of countries by the regulatory body. So these countries would have met some threshold of requirements. So what it means is that Nigeria agrees that these countries have met the basic standard for data protection. For instance, if you look at the countries within the EU that are subject to the GDPR, you would agree that such countries have the basic standard of legislation, so to say, on data protection. And it will be unusual for a country like Nigeria to think that such European countries do not have adequate protection for data of personal data of data subjects, maybe from Nigeria. So if you have anything to do with a data controller and they collect your data, and they are supposed to, of course, they're supposed to make it known to you that your personal data is going to be transferred to another country, say UK, Germany, or China. If such country or the country that they want to transfer the data is not in the white list of countries published by the NDPC, then you need to specifically give your consent to the transfer of your data to such country. Then let's come down to the main conversation: electronic consent and compliance requirements. Now, the section 26, subsection 27 of paragraph B of the NDPA provides that consent may be provided in writing, orally, or through electronic means. Now, let me mention that there is no specific compliance requirements when it comes to e-consent or consent that are manually given. When I say manually given, they are not electronically given. The same standard of compliance is required in both circumstances. Consents are subject to the same principles and laws. Therefore, notwithstanding the method through which consent is sought and obtained, the data controller must ensure that the legal requirements for consent discussed slides are complied with. So, certain things that you're supposed to do, you don't have to ensure that the consent is freely given, for instance, or that it is, or that the data subjects should be well informed of the whole thing around the processing of his personal data, who is processing it, is it going to be transferred to a third party, for how long are you going to hold the data and all that. So the law requires that whether it is electronically given or obtained manually, the same standard has to be complied with. Now, e-consent may be obtained in various ways. There are checkboxes. I've talked about, you log into a website, you visit a website, and then they bring out a checkbox and it is ticked and one is not ticked. And then you just click OK, and then you continue. So what it means is that they've obtained your consent without your consent, really. So there are checkboxes. Here, the user gives his or her consent by clicking on an e-box. So you could see something like, I agree or I do not agree, check boxes. So the check boxes are a valid and convenient way of obtaining this consent. When you are installing an application, for instance, in your mobile device or your personal laptop, personal computer, you get to a point where you have to click to agree to agree to the terms of use of that particular application or the privacy policy of that application. So this is also one of the ways of obtaining your consent to processing of personal data. It is also called as a click wrap agreement, but usually for when you are dealing with proper contracts and all that. So there is also what they call double opt-in. Here, this is where the relevant digital platform, at the click of a button, automatically sends a separate confirmation email to the data subject's email address. So you click on a button, on a platform, and then it sends a confirmation email to you saying that you should go to your email your inbox, click on the link to confirm, that you are opting into, the processing of your personal data. You're giving your consent, say, to receive subsequent marketing emails from the company, or, to the use of your personal data for other purposes. Then then there is a combination of click wrap agreements and double opt-in. So here you have A and B applying. I've read a couple of articles that advise for the use of this combination, these two options, just to make sure that it is not in doubt that the data subject is giving his or her consent. So the withdrawal of consent, we've discussed this before. Section 26, subsection 4 of the NDPA provides that the data subject has to be informed of his right to withdraw his consent. And this information has to be given at the time, before the consent is given. So if you look at this picture here, you will see this place. If you look at this place, you see where it says that you can unsubscribe at any time. So this is telling you that, you can give your consent now, but at any point in time, you can withdraw your consent. If you've been receiving marketing emails from companies, if you go down maybe at the foot of the email, you will see something like this, something similar to this. So they're telling you, that you also have the right to unsubscribe to the what is it called, to the marketing information that they are giving to you, but that you can withdraw your consent. You don't want to hear anything again from them. In some situations, where you had given your consent for various purposes, not more than one purpose, if you click the unsubscribe button, they will bring out something like a drop down will come out asking you to state which of the purposes you want to unsubscribe for, you want to withdraw your consent from. So it provides you with the clarity on the entire process. What did you consent to? What do you want to withdraw your consent from? So if you also look down here, you see that the privacy policy of this company was linked to the consent request form. So if you click on it, if you click on the privacy policy, the policy itself will come out so that you're able to read the entire thing that the data controller wants to do or is going to do with your personal data. So it's always advisable that you go through this process. You read the privacy policy. I mean, many people don't have the time to do that. Many people don't even care really, about what companies do with their private personal data. But except when maybe there is a breach or something, and then people start reacting. We've mentioned that information regarding the process should be made available to the data subject at the time of consenting, at the time of obtaining consent. So it's not after you've given consent or obtained the consent of the data subject, you start telling the person that he has the right to withdraw. The person needs to know that if I'm giving you consent today, I have a right to withdraw it, immediately or subsequently. Then the consent withdrawal process should be as easy as the process of obtaining consent. You don't make it easy for me, bring out check boxes for me to click, to give my consent. And then when I want to withdraw the consent, I'm required to send email or have a meeting with the management of the company or get a court order to do that. No, it has to be seamless. The same seamless process of giving the consent has to be provided for, withdrawing the consent. The right to withdraw of consent is not conditional. It can't be conditional. It can't be based on, before you can withdraw your consent, maybe you need to buy our product, you need to wait for 4 days, you need to wait for 5 days. No, it has to be unconditional. I have a right to give it to you. I have a right to give it to you unconditionally. I have a right to withdraw it unconditionally. Withdrawal of consent will not invalidate the processing activities carried out prior to the withdrawal of consent. So if you give your consent to a bank to use your personal data to open an account, to buy treasury bill for you, or you want to buy shares from, from the exchange. If you withdraw your consent tomorrow, it's not going to invalidate everything that had been done prior to the time, prior to the time you withdrew your consent. So you need to also bear that in mind as a data subject before you give your consent. Then there are other things that we need to note. In some digital platforms, you see that I've personally experienced this particular thing. I started receiving marketing information from a particular company. I can't remember when I subscribed to it. And then I wanted to unsubscribe from, their marketing emails. Each time I click on that link to unsubscribe, it takes me to something else that was looking like maybe, a hacker's platform or something. Or sometimes it doesn't, go through. It keeps hanging. The link continue to hang. So I can't progress to anything. So I realized that it was just designed that way to make it difficult or almost impossible for you to withdraw your consent or to decline from receiving further information from that organization. Then it is important that you link the privacy policy to the consent request form so that users can access all information and decide whether to give consent or not. If I go to your website, I don't need to start checking, where is the privacy policy? They're asking me to give my consent. So where do I get the information on their privacy, on their processing activities and all that? Just link it to the consent request form so that once I click on it, I'll be able to see all the information that you have. Do not use sneaky workarounds like making the accept button more prominent than the deny button. So you make the accept button or the consent button, I agree button, very bold. And then the deny button is very small, almost invisible. So that is not acceptable because what it means is that you're not giving a balanced info. You're not giving the user a balanced information with which he can make a decision. Data controller must ensure that it maintains a record of users' consent choices. So this is very good because of compliance requirements on the part of the data controller. The NDPA puts the burden of proof when it comes to data subjects' consent on the data controller. If I said I did not give you my consent as an individual, you're not going to ask me to prove it. You're the one that will prove that I gave you my consent. So it is therefore important that you keep records of the consent process. The consent should include, who consented to what, who opted out, which means you need to get the person's name, the user ID, for instance, the email address, other identifiers, including maybe the IP address. If there is a phone number, you can get it out as well, depending on the information that they put in while giving the consent. Then, at what time was the consent obtained? At what time the data subject withdraw his or her consent? So you need to have a consent management system that can take records of all these things. How they agreed or denied consent, the specific form or place on the site where the user consented. Is it a pop-up or they sign up on a form? Did they send an email, for instance? What they agreed to or opted out of? What exactly did they consent to? Did they consent to receiving marketing emails? Did they consent to telephone calls? I've occasionally received phone calls from maybe my ISP or HMOs or insurance companies asking you did you consent to that? That they have to use your phone number to make calls or to send you text messages. When you give your consent, did you consent to just receiving emails or did you consent to receiving SMS as well? If and when they withdraw consent. So you keep a log of any time a user changes their consent preference. So if your consent request form is designed to obtain consent to more than one purpose, more than one item, your log, your consent management platform need to be able to show whenever the data subject comes up to make certain changes on their consent preference. I can say, oh, I don't want to consent to item ABC. And tomorrow I come back to consent to give my consent for item ABC. Your consent management platform should be able to pick out these changes so that in a compliance situation, you'll be able to prove as a data controller that, look, this person had come to make changes to his consent. Yeah, I believe I would have exceeded my time, but I think this is my last slide. So thank you very much.
Okay, thank you.
Yeah.
Okay, if we have any, just drop them in the chat box. In addition to what Mr. Glitchy have said, one of the ways there's also implied or constructive consent, which arises in a situation where data subjects are participants in a public event or meeting, such as ourselves here. And if you had previously remembered, I had informed everyone that the meeting will be recorded for reporting and for reporting purposes. So this is also one of the implied ways of implied consent, and where data subjects and participants, such as ourselves, can give consent in situations like this so that our pictures can be used for, let's say, media rounds and the likes. Okay. Our second speaker and probably last speaker for today is Ms. Adeshola Oguntimehi. Ms. Adeshola Oguntimehi will be speaking to us today, and she's a cybersecurity professional with experience as a GRC analyst and founder of Cyber Patron Network. Ms. Adeshola, the floor is yours.
Hi, good morning. Yeah, it was still morning. Good morning, everyone.
Sorry that like we isn't.
Yeah, because the name was
message
30 minutes.
on
I saw in my mail, so I have to like size it to like
I'm
I have a lot of things lined up today. So am I going to make my sending my slide, or you're going to present? Or are you
No, you
displaying
can
my
you can
slide?
just you can no you can just explain your slide and speak on it.
Okay, all right. So I just want to know in case if I have to open it up right now. All right, so let's get to it. Good morning, everyone. Once again, my name is Adisola. Yeah, so I love what the first speaker said. He has like shed more lights on NDPA itself. Like, it's so amazing to see that it exists, but most of us that are into GRC, sometimes we totally forget that it exists because our mindset is set towards GDPR and every other EU data processing laws, forgetting that we always have NDPA. So I always tell my mentees, because I do GRC training as well, so I always tell them that regardless of whatever career path you're in GRC, always remember that you're a Nigerian and you work in Nigeria, you have to remember your NDPA. So I'm thankful that we have that already explained to everyone. So what do you think happens to your data when you sign up on international, let's say social media platforms, or you fill the form, or you're traveling out of the country and then you're filling your details from MM2, and then you're, you're getting to where you're going to, and you're seeing details about you there. How did they send those information? Sorry, I'm pulling up my slides right now. How did they send those information through? You have to think about those things as well. You might be wondering what cross-border transfer really is and how much of your data is being used or processed by other people or countries, countries, continents, or whatever it is. Sometimes we just fill forms. We don't care about, oh, what are they using these things to do? They're just collecting information from us. What exactly are they using these things for? We don't know. All we do is go online, click on anything we want to do. It took me a while to start. It was when I started out in cybersecurity that I started initiating this thought process of, okay, I have to read the privacy policies to know what exactly are they using my data for. It took me a while because all I want to do when I go online is I just want to sign up for whatever it is I want to sign up for. I'll just click on the yes, agree, and then I'm done. And that's all. But now These past 3 years of my life has really changed. When I go online to sign up for anything, I read through what is my data going to be used for, how are they going to be processing my data, because I know these things. It is only for the rest of us that probably are not familiar with it, that will probably don't care, like whatever it is, let's just get this done and over with. Sometimes we just wake up one morning and just say that we're signed up automatically on another person's mail, and you'll be wondering, I don't know these people, how did they get my information? You might have signed up on a website or any platform where your data can be sold to a third party, and you will never have any right to sue them or anything, because when signing up, there's always a consent form there stating that you need to understand that your data is going to be used for certain purposes outside this platform. So those are the things that we need to get familiar with. And luckily for us, we're in a country where court cases are not even taken seriously like that. So how many people do you want to sue? So let's just help ourselves by getting familiar with these things. And then we go to the introduction, which is the topic is just shedding light on the e-consent, which is electronic consent, and then cross-border data transfers. That means your data is moving from maybe Nigeria to another country entirely. How is it being done? Who is automating all these processes? Is it right? Is it wrong? So this is what we're going to be talking about. We're talking about the digital technologies. Like right now, we have a lot of digital technologies coming up, like emerging almost every year. We have something new coming up. A few years ago, there was nothing like TikTok, but now almost half of our population in the world, everyone is on TikTok, and then Facebook, WhatsApp. Most of these platforms are not even Nigerian owned. They are all international platforms. So you have to sign up there, put in your information, put in your PII. What happens after doing all those things? So that's why this topic is very exciting for me, because I need people to understand that you don't just sign up and then let it go like that. There's many more things that you need to understand about your data at rest, your data in process, and your data in transit. What exactly are they doing with them? We have the e-consent cross-border data transfers, which is a mechanism that allows individuals to provide informed consent digitally. When you're giving out your consent, it means that you've read through the privacy policy or data privacy policy, and yes, I'm agreeing for my data to be used for whatever they want to use it for. We don't read it, we just click on it and then we move ahead, we move along with it. So we have the ethical landscape as well. These are the three things that are more important that we're talking about in the topic today, which is digital technology, e-consent, cross-border data transfer, and the ethical landscape. Whatever it is we do, especially as a cybersecurity professional, everything we do has to be ethical. You cannot do unethical things. Being ethical has to come in with your data processing, what you're doing with people's data. Sometimes when people fill forms for my community, I always tell them, no matter where you are, if they're asking you, if you're filling a form for, let's say you're registering for a program and you feel like they're asking you too much information, I think you should go to their data privacy policy and read through it and then see what these data are going to be used for, because there's certain information that people should not even get from you on some level. So we need to be very, very careful of what we do online and how our data are being processed. These are things that we can do ourselves. Sometimes if you request too many information from me, I'll probably just cancel it and not get ahead with it. Like, what do you want to use all this information for? You can chase a lot of things, but you may probably not be able to chase after these people. So going to the ethical consideration, we talk about informed consent and the challenges and the solutions to this. And then we have the autonomy, which is the ensuring freedom from coercion. It means you're not forcing someone to put up their information on any social media platform for you. The vulnerability that comes with it, and then we have some case studies that we're going to do, but we're not going to talk about everything, and then we'll just have to pick on the most important aspect of it. So the e-consent represents a significant shift from the traditional paper-based consent process to digital platform that facilitates the collection and use of personal data. Normally, before, we used to write information on papers, like
Miss Adisha.
20 years ago, write on papers. You go to your school, like Now everything is on those databases. So that is where the digital technology comes in.
Mr. Adeshola, your line keeps breaking off. We can hear you, then we can't hear you. Can you hear me?
All right. So we have the challenges as well. With those challenges, we always have a solution to all these transfers. Most of the challenges, can you hear me?
Yeah, we can hear you, but it's breaking at some points. Like we won't hear you for like a bit, at least 2 minutes or something. I don't know whether it's the network.
Yeah, I don't know. I think it's probably the network. I don't know if you guys can hear me clearly because I'm trying to even switch my my network.
Yeah.
But can you guys hear me now?
Can hear you. We can hear you.
Okay. All right. Thank you very much. So most of the challenges comes with complex and lengthy consent forms. Like I said, when we go to the data privacy form that we see online when we want to sign up, the time it takes to even read through them is very exhausting. So now what we're doing now is to shorten the length of those forms. Like you have to make it very exciting for people to read, something to hook them up when they want to read or once they want to sign up. When it's too lengthy, it becomes a problem for people to even understand. Digital environment encourages a culture of click consent, yeah, where people just don't read through, just click and then without fully reading or comprehending what your data is being used for, which is what almost 90%.
Mr. Adeshola, I think if it's possible for you to leave the meeting and join again, I don't know if that's possible because we really cannot. We've stopped hearing you completely. Okay. While she's trying to join back, I think Iene Dominic has a question from Mr. Kilichi. She says the NDPC, I don't know if Mr. Kilichi can hear me, the NDPC just fined Fidelity Bank 555 million on the backdrop of a complaint made by it. Okay, she's back. Okay, I can hear you.
All right, sorry about that. I think my network went and totally off. I need to start sharing again. I'm really sorry. Okay. Can you guys see my screen?
Yeah, I can see.
Okay, thank you very much. All right, so these are the challenges that we face, which is complex and lengthy consent forms. When they are too lengthy, it becomes a problem for people to sit and read through it. So now most I think it's a website that we developed recently. We make sure that we reduce it, and then we every lettering that we put in there, the most important information there are in bold letters. So it attracts people to even want to read it. But when everything is smothered up and it's very tiny to read, people don't want to go through all that. All we want to do is to agree and accept, and then we're done with the thing that we want to sign up for. And then for the digital environment, the click-through consent is just the most important thing for us. We just want to click and then get it done, and we're done. So we have the informed consent challenges and solution. What are the solutions? What solutions do you think we should give to these consent forms, making it very easy for people to sit down, read through it, and then take their time to even understand what policies they are doing. Because I feel like when people are going to the hospital and then you have to sign some forms, you know, maybe someone is going into surgery, you want to take your time to read through it. It's like, okay, this is the matter of life and death. We need to know what we're consenting to. These are the things that I don't know. I think it gives people this fear, like, okay, let me sit down, let me calm down and see what I am actually getting myself into. Or once they want to apply for loans, those things are the ones that triggers people like, okay, let me sit down and read through what they are sending to me. But when it comes to every other thing, we really do not care. So what's the solution? Like I said earlier, the consent form has to be clear and plain, make it very easy for people to read through. You know, interactive tools such as maybe videos. Yeah, if you're writing it in a long text like that, you can also insert a video as well, so that if I can't read it, I can watch your video and listen to whatever you want to say about what I'm doing. You know, people grasp more on video. Some people prefer to use video to read or study than reading through in a book or any exam or whatever it is. And then the process of obtaining consent should be transparent, you know, allowing individual to review and adjust their choices. I can decide to, okay, today I don't want to use my data for any third-party activities or events. I can go to your website and then, you know, deactivate if I want to. It should not be difficult. When you're not doing that, that means you're coercing people to oblige to whatever it is that you want. So you have to make sure that your consent form, your e-consent form, is very easy for people to go back there and say, okay, you know what, I'm no longer interested in this deal. You can't be selling my data like that. Or how are they getting my information? I want to cancel this deal. You know, it becomes very easy for people. Make it easy, very easy for people. Then it attracts them more. Like, okay, you know what, let me just use this thing for a month. Once I'm done, I can go back there and then sign out and say I'm not interested anymore. So those are the solutions to the e-consent challenges that we may have, you know, and the solution, the challenges we have, the length and everything else. But these are the solutions that we are able to profile. And I believe that this would help everyone to understand when you're writing maybe policies for the organization. Either we're in GRC, we always tell people when you're writing your policies for your organization or a startup, make sure that they're always plain, simple, and not too ambiguous for even your colleagues to understand. And then we are going into the autonomy, ensuring freedom from coercion. Like I said, you don't have to force people to do things according to how you want it done. You have to do things according to how they want it done. It is my data, it is my information. Anything I want you to do with it is what I'm allowing you to do with it. And when I don't want to partner with you anymore, I am free to take off my data from your platform. It doesn't have to be a problem for anyone else. So autonomy is a fundamental ethical principle that underscores the right of individuals to make their own decision free from coercion and undue influence. You know, however, the digital environment can sometimes blur the lines between voluntary consent and coercion. Sometimes you don't know the difference. Another time you may just sign up and then be thinking, okay, you're free. Then you will still realize that, oh, they are still removing my money from this card and I already deleted it. It's still there. Sometimes they'll blur that line between you taking off your permission and then your backend data is still with the company. So they can still do anything that they want to do with it. Those are the problems that we have in the modern day technology that we use right now. And some companies that just decide to like, okay, you know what? For you at the front end, it's been deleted. For at the back end, we still have access to your PII and your card information. So those are the issues. If you don't know, you will not be able to sue anybody for it. So ensuring autonomy means that individual must have the freedom to consent or refuse without facing pressure or negative consequences. Sometimes you would hear of cases between clients and organization over data processing or data issues. It occurs a lot. I think I read some as of 2022 where a client was suing, I can't remember, maybe WhatsApp or one of these social media platforms on receiving maybe mails, or someone had access to their information and they were sending the mails and like blackmail or something like that. Where did I put this information? Then it became a very huge case. So this is where the autonomy from ensuring freedom from coercion comes in. You have to know what your clients will face, and you personally need to know what you're going to face if you decide to withdraw your data from these things. So, which is why I am saying that take your time to read through data privacy policies and look at what your data are being used for, you know. So to safeguard autonomy in e-consent, organizations must design their consent processes to avoid coercive practices, which is, like we said earlier, which is clear alternative for those who choose not to consent. If I don't consent to this, do I have any other alternative? You have to provide that, giving them the comfort that they deserve on your platform. If I don't want you to sell my data to a third-party vendor, what else can I do that gives me peace of mind? Like, okay, yes, I'm safe here and I can still use this platform without it, So for example, instead of presenting consent as a condition of service access, organizations can offer tiered consent options that allow individuals to choose which aspect of their data they're willing to share. I can decide to tell you, okay, today you can use my email address or sell my information to, let's say I register for a gym, and then I know that I will not be able to, or okay, let's say I move from Nigeria to, let's say, the UK, and then you have a branch. Let's say there's a branch of, what's the name of this gym? It's popular gym. Can't remember. A gym there as well that they have like another branch. I can decide to, like, okay, you can give my data to your UK branch. So when I get there, it becomes very easy for me. This kind of thing. You're giving them an alternative. I can sign up for that and say, okay, use my data for this access, but don't sell my data to these people. So those are the things that people need to get on your website or on your forms, whatever it is, that gives them so much comfort. Like, okay, yes, I signed up for this one. I can use my data for this. If I don't want my data to be used for maybe people selling food or diets or vegans, I can tell you, oh, I don't want my details to be shared to vegans because I'm not interested in being a vegan. Just give my information to maybe people, anything related to gym and other assets like that has to do with health. I think that is part of the e-consent that we are looking at. And there are vulnerabilities. Sorry. So vulnerabilities, especially special consideration for people, vulnerable populations. We all have aged people in our society. My aunt is 3 years old. She will tell me that I want to be on Instagram because a friend sent me a video on Instagram and I want to see what is going on. Or she'll send me a link and say, okay, look at this link. Let me click it. And I'll tell her that it's only on Instagram you can access it. And she'll open Instagram for me. These people will not take time to read through consent and whatever you have that is so bogus on your consent form. They just want to sign up and move according to whatever it is that they want to do. So you have to make sure that whatever it is that you're drafting out works with them as well, including minors, elderly people. Now we have social media rights that says that only 18-year-old kids can have access to this type of platform. And some would say, okay, children can have access to this platform. Now, luckily for us, for cybersecurity experts, we have those that so we have social media platforms that allow teenagers, the ones that your kids can use, the one that use the Coco Melon, all those channels, they can also sit there and also watch something. For us that are into cybersecurity, there are ways in which we can block access to certain things from allowing them access them. When you go on their tabs, there are certain things you can block from them so that they will not be able to access the whole wild web like that. So these are the things that we need to consider as well when we are putting out forms, especially when our forms are general. They don't relate to just the youth only. We're talking about the vulnerable people in the society, the aged, the teenagers who wants to also have access to these things that we have. We have to consider them when we are putting out our forms and our policies as well, or data privacy policies as well. So the vulnerability special consideration for vulnerable people in society, organizations should adopt tailored strategies to obtain and verify consent, simplifying the consent process, providing additional explanation or using alternative method of communications. Organizations should also regularly review their consent processes to identify and address any barrier that might prevent vulnerable individuals from understanding. I think there are certain forms now that allows people to, you can translate it from your local, from English or any language to your local dialect. That gives you more comfort to sit down and read it. Imagine reading a consent form or a policy form in Yoruba, in Igbo or Hausa, or reading in Chinese, Mandarin, or whatever it is. So those are things that gives people comfort. Everybody is not digital literate. So for those that are not digital literate in our society, we have to also create an environment for them to feel very, very safe. So we have a case study here. We spoke about the use of the healthcare industry and also social media platform. I think you would see this on the slide, so I won't take much of our time on that. Sorry, someone speaking. All right. So we have, okay, so for the cross-border data transfer, ethical considerations are, we have the data privacy. We all know what data privacy is for us are into GRC. Once there is a risk, in every situation, there's always a risk attached to it. But no matter the risk, there should always be a mitigation strategies. How do you want to contain that risk when it happens? Especially for your data privacy. When there's a data breach, how do you want to mitigate it? How do you want to communicate with your customers as well? We have jurisdictional issues. You know, that navigating different laws and regulations from different parts of the world, China, Korea, Nigeria, Europe as well. How many countries in the world do we have under GDPR, EU law? How many do we have under PIPEDA in Canada as well? We have to also note those things. We have to note them so that when we are writing, talks about, it covers all the provinces. You don't carry data that are for GDPR and then give it to PIPEDA. It doesn't work that way. And then we have to survey the risk and the consequences of data breaches, most especially. Then we have a case study as well, which is example of cross-border data transfer. Then we have data privacy and the mitigation strategies. So I think I'd like to talk about this one. So now we have the standard contractual clauses, which is the SCC. So which means that they should all adhere to international data protection standard, even when operating in jurisdiction with weaker regulations. There's some parts of the world that the data privacy laws are not that strong, like we have NDPA here, you know, or GDPR or PIPEDA and all that. They're very weak. But at the end of the day, you still have to cover up for them. So don't think because they don't have maybe any law backing it up or backing up data usage in their country, then you can decide to just use their data anyhow. You know, you have to consider them as well, and also implement technical safeguards such as encryption, you know, maybe advanced encryption standard or any other one that we have out there, and also ensure anonymizations. Don't expose people's data out there. You know, you can hash, you can salt, you can use any encryption means. When your data is at rest, when your data is in transit, always ensure that anonymization is done. Cover people's information, especially in the health sector. People don't want to come online and then see that, oh, my health status is already revealed because there's data breach in the company that I registered with. You know, so we have that as well. And then each jurisdiction has its own legal framework governing the collection, usage, and transfer of personal data. Like I said, we have the GDPR imposes strict requirements on data transfers outside the European Economic Area. The United States follow a more sectoral approach with different law of different type of data. We have different law for different kind of data in different countries. It is not just going to be NDPA generalizing on everything. We have different branch that takes charge of each data that we are using. So ethical consideration demands that organization not only comply with the law of the country in which they operate, but also uphold the highest standard of data protection when transferring data to jurisdiction with less rigorous regulations. You know, so this is just how it works for cross-data transfers. And then we have the risks and consequences of these actions. When we have risks that expose individuals to heightened risk of surveillance, particularly when data is transferred to countries with extensive government monitoring programs. What solutions do we have? Carefully selecting data storage location, ensuring encryption, like I said, implementing policies and limit the scope and duration of data transfers. You know, so greater transparency and accountability in government surveillance practices, working with policymakers to develop legal framework that protects individual rights while balancing legitimate nation security interests. This is one thing that excites me when I have lawyers that tells me, oh, I want to go into GRC. How do I come in? I'm like, oh, with the knowledge that you have in law, I think you would thrive so well in GRC. And that is one thing that I've made me so happy, like bringing lawyers into cybersecurity, and they're focusing more on GRC because we need them when it comes to making laws and legal framework that protect individual rights in the society. So we have a case study here that also talks about example of cross-border data transfer. You know, we have the Shrem 2 decision by the European Court of Justice. We can read more on that when I share this slide. I think this slide is the camera. Use of cloud services by multinational corporation. And I would like to say something that even when we feel like the cloud is the safest area, the cloud is also not safe because human is the weakest link in cybersecurity. human is the weakest link in anything that we do. So as long as it's human that comes together to form these cloud security purposes, they can also hack into it. Animals will not hack into it. Human create malwares, they create bugs that can infiltrate the cloud platform as well. So cloud provider often store data in multiple locations across the world, creating potential risks if data is transferred to countries with weaker protection law. So the cloud security is safe, but not 100% safe. That is just what I'm trying to address. So addressing ethical concerns, we have transparency, privacy by design. The security has to be robust and regulatory compliance, adhering to data protection regulation of each country that you are in, and then accountability, establishing clear accountability mechanism. People's data cannot just disappear just like that. You need to have an accountability measure to let them know what this is used for. And always have a backup system as well to cater for these things when the need arises. Then we have transparency, clear communication, and data subject rights. Like I think I've spoken about that before. And there should be transparency in your legal requirements, but also an ethical obligation. Don't adopt a privacy policy that are not written in plain language and easily accessible to people, because you know that there's a platform that you will create that are not just for people in Nigeria only. Like we have, let's say WhatsApp. It is not used by Nigerians only, but luckily for us, when you go there, you can change your setting and then change your language to English. That is you making it very convenient for people. Every policy that you write there for them to understand has to be written in clear language. You can't just present to us in English and then give us policies that are written in another local language that we will not be able to read and understand. Sometimes we transcribe by maybe copying the information and putting it online and then say, translate for us. So additionally, they should provide users with tools that allows them exercise their data subject rights, such as the right to access, rectify, or delete personal data. This alone excites me so much. Like when I'm done with a platform, I want to go there. Like a few days ago, I subscribed for Showmax, and I'm like, okay, you know what? I don't want them to keep removing my money because I'm very busy. I don't have time to start watching TV. So why do I want them to keep charging me? And I went to their privacy policy, I read through it, and I deleted my card information from there. So once I'm done for this month, I'm no longer subscribing to those platforms. It makes it very easy. So if they now debit me by next month, then there's going to be an issue with me and them. Like, I thought I already deleted my information from here. So this is them making it easy for me to know that, okay, you know what? When you're tired of us, please, you can decide to exit when you feel like it. So we have privacy by design, implementing data protection measures. It is an approach that integrates data protection principle into design and operations of system and process from the outset. Once you're starting out, you're including these informations for them to. It's not like when you're starting out and then it's at the end of it all that you want to start talking about data. As you're building, you're thinking about, okay, what data are we gathering here? How are we going to make this thing safe? What encryption method are we going to be using? Do we have a backup for these systems? All those things has to come into play. So example of this privacy by design include minimizing data collection to what is necessary. If you're filling a form for a training, like let's say a GRC training, and then I'm asking you for your card information, your CVV numbers and all those things, you'll be wondering, why are you collecting so much information? What do you need my card details for? This is where we need to start asking questions. Minimize the data that you're collecting from people to whatever it is that is necessary for you to carry out what you want to carry out. They're using strong encryption method, to protect the data at rest and the ones in transit. A man-in-the-middle attack should not occur whereby data of individuals or your clients are hijacked along the line, because we have something in cybersecurity called man-in-the-middle attack, whereby someone else can stay in the middle and hijack the data that you're maybe sending to another person. So we need to be very careful, and regular auditing, for compliance, and then the data protection has to also be looked into. You have to regularly audit. You have to check what is in trend now. Now we have the EU AI policy coming up. I don't know if it's out there like that yet, but yeah, we have that coming up as well. So for those that are excited about AI, you should go there and read the policy EU has drafted on it. So it can help you know how far you can go and how far they can protect you as well. So we have a robust security measure for data protection, which is a critical ethical concern in both e-consent and cross-border data transfers. The growing prevalence of data breaches, cyber attack, and unauthorized access underscore the need for robust security measures to protect personal data. Like we have the CrowdStrike attack last month that caused an uproar in the whole IT world. Then everybody start looking into their system. Okay, what is it we're not doing right? What do we have to put in place for us not to be victims? Because they lost a lot of money and a lot of their clients will drop down. And I heard that some people actually sued them, because they cost them a lot of money as well. So we need to be very, very sure. Are we putting the right measures in place? Because every day there's a data breach. There are different cyber attacks coming up. Before the end of the year, you see here of another one that will go viral again. Or the minimal ones that we don't even hear about, that the company easily curtail within their IT system, and then they don't spread it out there. The other day we heard that GT Bank platform was hijacked by hackers, and then you can't access their webpage and everything else. We don't know how much they use in sorting that. Maybe that was a ransomware attack or something. Like maybe they had to pay them to release the webpage again. So all these things, once it happens to someone, you don't want it to happen to you. So you have to start putting up measures to protect yourself, your organization force, and your client. Imagine starting a company with $50 million and then you're being sued for 100 million and you've not made that kind of profit in how many years of establishment. You want to be very careful and put necessary measures in place. So we have the ethical consideration demands that organizations take all reasonable steps to secure data, which we've spoken about earlier. Then we have the regulatory compliance adhering to data protection regulations. For example, the GDPR, NDPA, PIPEDA, FedRAMP, HIPAA. We have the PCI DSS. All those ones are regulatory compliance that you have to know which one your company falls under. So regulatory compliance is the key aspect of addressing ethical concerns in cross-border data transfers. It is very important that every organization processing data out of their jurisdiction take note of the other country where they are sending it to. What is their law on this particular data? Those things has to be noted. Adopting a proactive approach to data protection, regularly reviewing and updating data practices. If the ISO standard now is changing from ISO 27001 to 2002, you have to stay in trend to know what else has changed. What do I need to take out from here? And then adopting something else from the 002, like the NIST framework. When the govern aspect of it was introduced, everybody started, mounting up on it, like, okay, let me change, review, regularize, and then bring in another thing as well to curtail the NIST new update. So organizations should also be prepared to engage with regulators, participate in industry initiative, and contribute to the development of new frameworks that address emerging challenges in data protection. I think the only thing emerging right now that I've seen that everybody wants to be familiar with is the AI. And luckily for us, we have people jumping on it and they're trying to bring up policies to protect you and I, because a lot of us are going to be using AI. If you go on Twitter now, you will see Grok. You will go to on WhatsApp, you see Meta AI, those things. How safe are we when we use this medium? Those things should come in. So people were already drafting regulations, policies as well to address these things so that we don't just go online, behave the way we want to behave, and then there's going to be a problem later. Then we have accountability, establishing clear accountability mechanism, components of ethical data management. Organizations must take responsibility for the data practices and be prepared to demonstrate their compliance with ethical principles and regulatory requirements. Regulatory requirements are very, very important. So the solution to this is organizations should implement regular audit, assessment of data practices, including e-consent mechanisms and cross-border data transfers. They should also create clear channel for reporting and addressing data protection concerns both internally and externally. When there is a data breach somewhere in your organization and you feel like you've addressed it, it is okay to come out there to the public and tell them that, okay, this was the reason why you could not access our website for a while. This is the reason why you could not make transfer from your banking app because this also thing happened. You don't want to immediately do it to create a scare. Everybody will start transferring their money out of their bank like, oh, no, they may take my money. But immediately you've curtailed that issue, you should at least give a press release and then organize your lessons learned. What lesson have we learned from this? How can we prevent ourselves from this occurring again in our organization? So we have best practices for e-consent. They are the implementing e-consent mechanism, conducting data impact assessment, establish data transfer agreements, wherever jurisdiction, country you're sending it to, there should always be an agreement to this effect, and ensuring ongoing monitoring and evaluation. So implementing e-consent, so these are just like explanation of what I just stated here, so you can see it on your slide when it's shared as well. So the conclusion and the future direction is just, what adoptive approach are we going to be looking at to prioritize our data transparency, security, regulatory compliance, and also accountability? These are the things that we need to look at as an organization, also as individual, because a lot of us might probably want to start our own company later. You need to understand this thing. It is not just, sometimes we outsource these things to people, like, yes, I want to outsource them. When you outsource it, doesn't mean that you should not sit down as well and also read about it, understand it, because we sell our information and our details to even third parties. Even third party, there's something in GRC called third party risk assessment. The data breach or the issue may even come from your third party. Maybe the person that has the access to your client's data. You might pray from them that the data breach will occur. How do you want to curtail it as an organization using the third party system? So if you don't understand it, you will not be able to approach it. So it's okay for you to also have a compliance expert in your organization that is in charge and is monitoring all these things. And that's why I always say to people, or when I have security awareness creation period, I always tell organizations that I speak to that it is important that you have a compliance officer, a compliance manager in your organizations, because the moment you're working with people's data, you need a compliance person to be in charge of these things. You can't just undo things based on, let's just do it. Because when you are sued, you're paying much more. Some companies shut down totally from being sued only, and they will never rise again. Because when you're being sued $100 million, how do you want to get it? So it is important that we put these necessary things in place so that we can secure our company and also secure our clients. People lose clients every day. We move from here and jump here. Oh, this is the new one now giving us protection. Let's go there. It's better for my data to be safe here than to be unsafe here just because they give me maybe cheaper value or something like that. I'd rather pay more and get value than pay less for less value. So that's just what works for me. And there is a growing need for international cooperation to develop harmonized data protection framework that address the ethical challenges of cross-border transfer. I think we have that already in different countries in the world. You just need to know, what country am I transferring my client's data to? What country, like let's say you're doing a web development event, or you're starting up, you want to create a web page and then you're hiring someone from India or something like that. You need to know what their law states on data privacy, because your client's data are going to be with that person in India. How safe is it over there? Those are things that we need to put in place as well. And then in conclusion, we have the ethical consideration in e-consent and cross-border data transfer, and not only about complying to legal requirement, but also upholding fundamental principle of autonomy, privacy, and accountability. These are the things that make us, let's say, we're more human. When your privacy, your fundamental human right principles are upheld by organization, not just the government, because sometimes we always feel like it's the government that is in charge of all these things. No, it is you and I. It is you signing up on Facebook, on TikTok, on WhatsApp. How are you protecting yourself, and how is your organization going to be protecting you as well? Those things, they matter. So it's not just about the organization, it's about you and I, ensuring that we understand these things, and then when issue comes up, you can send them screenshot and say, according to your policy, you said that my data are safe here, and here I am. How did I get into this? So even if you want to call your lawyer by then to say, okay, this is it, you start posting screenshots. So when fundamental human rights for the digital and the non-digital literates are not upheld, there is a problem somewhere. So we need to look into these things. So the final say for this topic is just that everything that we've spoken about now is not just for compliance companies only. It is for private individuals like us. It is for GRC experts, it's for compliance managers and those that are upcoming in the industry as well, to ensure that they understand what data privacy is, what data policies are, what regulatory compliance am I supposed and framework am I supposed to understand as an individual and also as a company itself. I think that's all. Thank you very much. If you have any questions, you can direct them to.
Thank you so much, Adesola. But that was so insightful. I mean, I learned a lot. Like I said again, this additional the slides will be shared to every
Yes.
participant. So if you have a question, please just drop the questions on the chat box and we'll give the speakers a few minutes to answer the question. Okay, we have our last speaker for today who just joined us. Miss Winnie Ingige. I don't know if if she can hear me. Miss Winnie Ingige, please. She's she's a lawyer and she's an experienced privacy and data protection specialist. So I would like to hand over to her now. Miss Winnie.
Hi, Chioma. Can you hear me?
Yes, I can hear you.
Okay, thank you. I'd like to request for you to please present the slides on my behalf.
Okay, that's fine.
Yeah.
That's fine. We can introduce yourself while I'm trying to.
Thank you. So my name is Winnie Ngige. I'm a lawyer and a data protection specialist based in Kenya. I help companies within Kenya and the East African region comply with the data protection laws in their specific regions. Today, I'll be taking you through cross-border data transfers. What are the risks? What are the mitigation measures that you can put in place? As well as how to do a transfer impact assessment. And I am happy to be here.
Okay. Okay. I don't know. Can you see my screen?
No.
Okay. Okay. Can you see my screen now?
Yes, I can see your screen now.
Okay. So yeah.
I don't know why on my end it's very minimal.
Okay.
Are you able to enlarge it?
Yeah. Let me enlarge. Okay. Okay. I don't know. Can you see screen now?
Yes, I can see it now.
Okay.
Okay. Cool. So we can begin by looking at what is cross-border data transfer. And this basically means the transmission of personal information from one jurisdiction to another. So this could be either you're moving personal data from, say, Kenya to Nigeria, or from Nigeria to Ghana, or from Ghana to the UK. That will be regarded to as cross-border data transfer. And the data transfer can happen through various platforms or through various ways. For example, you can transfer personal data via cloud services. For instance, if you're using AWS or Microsoft server services, then you should know that you're actually transferring personal data outside Kenya. You can also transfer data, sorry, not outside Kenya, you're transferring a personal data to the other countries. There's also outsourcing. So by outsourcing, I mean you can have an organization that is handling, say, your IT support services that is based in another country. So whenever there's that particular relationship between the two of you, then there's possibly a transfer of personal data. This can also happen where there's a multinational company based in different countries. So within the specific group, the company can also transfer personal data amongst itself using various means. And you're going to see what are some of the ways that you can transfer personal data. And why cross-border data transfer is happening so much right now is because of the boom in the digital economy, which makes it easier for us to transfer personal data between the different countries and actually to trade within ourselves. And so in as much as, yes, there's ease of transfer of personal data, it is also important to ensure that we're not negating the need for doing compliance, because at the end of the day, if you do not comply with data protection requirements in relation to transfer of personal data, then it is possible that the specific regulator in your country will come for you. Choma, we can move to the next slide.
Yeah, so I think it just like the screen just froze. Hold on, let me share the screen again. Okay, you're already sharing your screen. Sorry, the system just froze. So I could not continue. Do you want me to continue sharing my screen?
Yes, yes,
Okay.
you can. Or are you having
Yeah.
a challenge on your end?
No.
Oh, you're
I'm
okay,
not.
okay, okay, sure.
Okay, so sorry for break. Okay, can you see my screen?
Yes, I can see your screen.
Okay.
You can move to the next slide.
Okay.
So let us look at some of the legal frameworks on cross-border data transfer. So depending on the country where you're based, you'll be subjected to a specific legal framework on transfer of personal data. So if you're within the EU region, we have the GDPR. So you can look at articles 44 to 50, which prescribe the specific requirements on your transferring personal data from the EU region and what you need to have in place. So this will include things like adequacy determinations by the European Commission or codes of conduct or certification mechanisms. If you're within Kenya, then we have the Data Protection Act as well as the general regulations, which you can look at section 48 to 49, as well as regulation 49 to regulation 48 to regulation 49. These are very specific on the requirements that you need to have in place when you're transferring personal data outside Kenya, including analyzing whether the country that you're transferring this data to has a data protection law that provides equal measures of protection as those outlined under the Data Protection Act. Nigeria also has requirements on cross-border data transfers. There's also Tanzania, and what I find interesting in Tanzania is that for certain categories of data, you actually need to get approvals from their Data Protection Commissioner. And then you have the Uganda Data Protection and Privacy Act, which has similar requirements on cross-border data transfer as those that are in Kenya. So before you transfer personal data outside your country, some of the things that you need to look at include So some of the things that you need to consider are what is your local context in regards to cross-border data transfers. So what does your law say when you want to transfer personal data outside the country? Do you need to get approvals from your regulator? Do you need to obtain consent from data subjects? For instance, if it's a transfer, say from Kenya, and it involves sensitive personal data, then you're required to obtain consent from the specific data subject before you transfer this data. You're also required to notify them of this particular transfer, as well as the risks and safeguards that you've put in place to ensure that their data is protected. Then you need to determine your legal basis for the transfer. So under different laws, you have different requirements on the legal basis that you can use to transfer personal data. So it can be either you're transferring that personal data based on necessity for you to perform a contract between you and the data subject. It can be to comply with legal obligations. Say someone has committed transnational crime, say a male, and they're being investigated, and a third country is requesting for this information and you're obligated to share the same, then you can use that as a legal basis. So basically for the legal basis, it is dependent on what the specific legal bases are in a specific law and jurisdiction. Then the other thing you need to do is conduct a transfer impact assessment. This just helps you determine whether the country where you're transferring this data to or the organization that you're transferring this data to has actually put in place proper measures to protect the personal data, and as well as see if you require maybe to get approvals from the specific regulator. You also need to provide adequate and sufficient notices to your data subjects. So you need to have a proper privacy policy or a privacy notice either on your website, or depending on how you interact with your customers, you need to provide them with sufficient notice on how you're transferring that data, who you're transferring it to, why are you transferring it, for how long will they have access to this data. All that has to be properly detailed. Then you need to establish which is the best or most appropriate transfer mechanism for your organization, which is dependent on the type of data that you're transferring. And you look at some of the transfer mechanisms that you can use. The other key thing is to keep a detailed record of the transfer. And this is mostly important to say a regulator wants to assess whether you're transferring personal data in an appropriate way. So that's why you need to keep a record. Then if you're required to consult your supervisory authority or your regulator, then it's important to do so before you transfer that data. You also need to inform data subjects of their specific rights with regards to the transfer and whether the other country actually would respect their data subject rights. Then you need to also assess if there's a supervisory authority in the recipient country who will be able to enforce the specific requirements of the data protection law in that country. If at all that country has a data protection law, then you also need to consider the type of data involved and the category of data subjects, because then now the specific responsibilities for the different categories of data will continue to apply. So for the mechanisms of cross-border data transfer, go into adequacy issued by the supervisory authority in a specific country, and they are mainly issued either to a specific industry in the country that you're transferring this data to, or to the whole country, or to a specific organization within that country. So if there's an adequacy decision that has been issued by your supervisory authority, the event now that there is no adequacy decision and you form part of a group of companies, then you can transfer personal data based on binding corporate rules. And these are just, I'd say they're like a contract. Yes.
Yeah. Please, can you throw more light on the adequacy decisions? The line was breaking at the point you were explaining. I don't think any.
Okay, sorry about that. So for adequacy decisions, I was saying these are issued by your supervisory authority in your specific country. So what these do is they allocate or they specify the specific countries where you can transfer personal data without requiring any other mechanism to supplement that transfer. So for instance, if it's within the EU region, if the European Commission has given an adequacy decision on a specific country, say for example, there's an adequacy decision on the UK as well as Japan, so you can easily transfer personal data to any of those countries based on the adequacy decision. Then now I was talking about binding corporate rules, and I was saying these are mainly used within a group of companies. So say, for example, you work at something like MasterCard. MasterCard is based in different countries in the world. So for MasterCard, they use binding corporate rules when they're transferring personal data within the group of the company. So these binding corporate rules are very specific on the requirements for each country with regards to how that personal data will be transferred, what are the security measures that will be implemented, who is going to be responsible for implementing and overseeing the binding corporate rules. In the event that there's a breach of personal data, who will the data subject complain to, with the specific supervisory authority. All that will be detailed in binding corporate rules. Then we have standard contractual clauses. these are mainly pre-approved by the supervisory authority. So for instance, if it's within EU, we have standard contractual clauses that are specific for controllers to controllers who are based within the EU. And then if you're transferring that data to a third country, then you can use the standard contractual clauses between controllers and processors, and you can edit this to fit your specific reason for the transfer. But there are certain things within the standard contractual clauses that you cannot edit. So when you're using standard contractual clauses, you do not need to get prior approval from the specific regulator. Then we have data transfer agreements. These are agreements that you enter into between yourselves and the third country or the recipient of this particular personal data. So it details the specific requirements that you have for them to process that personal data, how they will safeguard that data, what are the minimum requirements in terms of security that you require them to have? Do you require them to maybe train their employees? How regular will be the trainings? Will you do an audit? Do they need to give you a report, maybe say at the end of the year, on how they've been implementing the provisions of that specific transfer agreement? Then the other thing is regulator approvals. So like I had mentioned, in Tanzania, you need to obtain approvals from their regulator before you transfer personal data. So you need to do that. And then we have codes of conduct. So these are mainly industry specific. They just outline what are the requirements maybe when you want to transfer personal data. A good example is the PSI DSS, which is applicable to the payment industry. So you can use that as a transfer mechanism. Then we have certification mechanisms. This also have to be approved by the specific regulators. And this includes the ISO 27001. All the ISOs basically would fall within the certification mechanisms as a basis of your transfer to another country. So as we are dealing with cross-border data transfers, it's important to note that there will be certain issues or risks in relation to the transfer of data. So a good example is there could be data breaches due to increased vulnerability in countries with less protection. So if you're transferring data to a country that, say, does not have a data protection law, that is already a risk, because if there's a breach of that personal data, then what will data subjects be required to do? Who can they report to? Who will enforce their specific rights? Then there's the issue of government surveillance when you're transferring personal data. So you need to also look at that. If you're transferring personal data, say, to a country like the US, and we know the government has almost unfettered access to the data within the country, then you're putting your data subjects at a form of a risk. And you can look at the Max Schrems decision on the Privacy Shield, where Max Schrems argued that the US did not afford a proper adequacy mechanisms with regards to transfer of personal data from EU to the US. So you can look at that for the specific details and what the Court of Justice of the European Union said with regards to this matter. Then the other thing is legal uncertainties due to differing requirements on cross-border data transfers. So each country is very specific on the requirements that they have on organizations in relation to transfer of personal data outside their country. So for example, in Kenya now we have the computer misuse and cyber crimes critical infrastructure regulations, which supplement the Data Protection Act with regards to cross-border transfer of data. And now for this particular regulations, what's has come into play is that there's to another country. So this includes the financial services, the banks, and all that. Then we have strict data localization requirements, and this is mostly there for countries to try and protect the sovereignty of their data, and just for economic or national security reasons. Then there's also lack or inadequate control or oversight when you transfer this personal data to another country and you have no control over how they're going to protect that data because you're not even based there. Most of us, for instance, for cloud services, we only sign the specific SLAs, but we don't even interrogate how are they actually going to protect this data in the way that they're saying they're going to do. And this came into play in Kenya during the 2022 presidential election, where it was impossible for the petitioners to actually have access to the servers because the argument was that the servers were based in France. So the argument was that since the time difference issue, it was impossible to wake those people up for them to share that data. So you can begin to see why cross-border data transfer can become a dicey issue for specific data subjects as well as specific categories of data like election data. Then we have third-party risks, and this was touched on by the previous speaker, where if the country or the third party that you're transferring this data to does not comply with the contractual requirements that you've given them, then what will be your recourse? Are you going to sue them? And if you're going to sue them, is it going to be in the country where they're based, or is it going to be in the country that you are in? And that also speaks now to the next point on jurisdictional conflicts. So in terms of data protection implementation, especially if it's within a group of companies, how do you determine what is the choice of law that you're going to use? Because of course you're based in different countries. Some countries might have a wider scope with regards to what is protected under their specific data protection law. For example, in Rwanda, the personal data includes the data of a deceased person, but then that is not the same requirement say under the Kenyan Data Protection Act or the Nigerian one or the Tanzanian one. So begin to see why jurisdictional conflicts can become an issue when you're transferring personal data. So maybe before we go to how to do a transfer impact assessment, if there's anyone with a question, you can ask.
I don't know why that is not showing very.
Good afternoon. Good afternoon.
Like is
Yes, my name is Benjamin. Please, my question, please, I would like you to show more light on binding corporate rules on that contractor clause.
Sorry, I can barely hear you.
sorry, can you
No, I
speak?
said,
Okay.
oh, yeah, I said, please, I would like you to show more light on binding corporate rules and standard contractor clause.
You'd like clarity on standard contractual clauses and binding corporate rules.
Yes, please.
Okay. So,
Should I go back to
yeah,
that
you
page?
can go back to that page.
Yeah, it's here. So it's under general mechanisms for cross-border data transfers. Hello?
Hello, yes, trying to get back. I think I have an issue with my internet connection.
Okay.
Give me a minute. Try and fix that. Okay, so for binding corporate rules, these are specific within a group of companies. So say you're operating in Kenya, in Uganda, in Nigeria, in Ghana. So you're one company, but you have subsidiaries in these 3 other countries. So what you can do when you want to transfer data amongst the group of companies, you can use binding corporate rules. So these are like a contract. that binds all the organizations or all the subsidiaries within the larger corporate group. And so they're very specific on how you'll transfer that data to the specific subsidiaries. What are the minimum requirements that you have for each country in terms of the security measures that they need to have in place? Do they need to train their staff on how to handle personal data? What are the data subject rights that individuals
I'm sorry, Vinny, we can't hear you. Hello, Winnie. Can you hear me? Hello. Okay, while Winnie is trying to connect, please, if you have questions, I think you can drop them on the chat box so that Ms. Adishola can answer the questions on the group chats. Okay, please, if you have questions. Sorry, I can't hear any. Is anybody saying anything?
Okay,
Okay,
I
I
should
think,
just, sorry, can I speak?
yes, you can go on.
All right, so I think there's some questions here that was asked from, I can't find the person, Dominic. So I'm just going to answer generally so that other people that want to like learn from it as well. So he said, from my presentation, it shows that data protection and cybersecurity are intertwined. To make a good data privacy professional, is it possible to do one and not necessarily do the other, or both go hand in hand? So both goes hand in hand. You cannot leave cybersecurity out of data protection, because when you want to journey into this kind of thing, you have to understand what cybersecurity is. It's from cybersecurity you learn encryption method, social engineering tactics, how hacking is done. You have to get familiar with those things before you now go into data privacy. You don't just go into data privacy to understand, because once you dive into data privacy first, you would be taken back to so many things that involve cybersecurity. It's better for you to just start from that fresh ground, understand those little things that are involved. We have different kind of encryption method. We have hashing, we have salting. You need to understand those things before you even dive into your data privacy career as a privacy officer or anything in citizen privacy. And then, so he said also that, okay, Demola asks that is regarding situation where an individual decides to get funds from loan app and later defaulted, and the loan company threatens to make the information of such person available to their contacts. Okay, so this is where your privacy policies come in. Before you apply for loan anywhere, I think they should give you their the policies of the company in relations to loan application. What did they tell you? Because some of us don't care because we're desperate to get that quick 20,000, quick 500K. We don't care what happens. Some would have told you that if you default in your payment dates, this is what is going to happen. You say, okay, go ahead. And then you don't know you're going to default. And then you now start posting RIP of your pictures everywhere, or harassing your family members and friends online that you're owing, all those kind of things. That is where you have to take your time to read through their policies. What did they tell you? So there's no way you can sue them when they already told you that this is how this thing is going to be at the end of the day, and you default. Whatever they want to do with your data at that point, they are free to do it because you already signed it that, okay, yes, fine. Whatever you want to do, go ahead and do it if I don't pay at that particular point in time. Because I've never had first loan before, so I don't know how the loan app works, but I'm very sure But there is no loan app in Nigeria right now that would not have a privacy policy somewhere, or what your data can be used for. So these are the things that you need to take charge of, read through properly before signing up for loans. So it will not be your fault and it will be their fault. Does someone say something on Showmax subscription on your card? So that means it's a back end issue. It's a back end issue. You need to go and maybe go to their, I don't know if they have an office, DSTV. I think DSTV is in charge here. Go to their office to speak with them, and for them to stop debiting you is a back end issue. So you have to find a way to mail them, let them know that they're still debiting you. And if they don't stop debiting you, even after you've taken the necessary step, then you can involve your lawyers and get your money back. You can sue them and get your money back. I think that's easy to easily assess by you. All right, I think those are the questions that I have from there. Thank you.
Okay, thank you, Ms. Adishola. For Mr. Kelechi.
Yeah, thank you, Choma. I think I have two questions here. Okay, the other one is not really a question, just asking for the materials that okay, later I can drop my email address with you, then maybe later you just chat me up. The question on Fidelity Bank, the penalty against Fidelity Bank. So if you look at section 48, subsection 2, paragraph B of the NDPA, that's the Data Protection Act, it gives the commission the powers to make enforcement orders against data controllers or data protections or data processors in an event of breach or violation of the relevant laws. One of the enforcement orders that the commission can make is to order the data controller or data processor to pay compensation to a data subject who has suffered injury, loss, or harm as a result of the violation. Now, what it means is that if you petition the commission that your privacy right has been violated by a data controller, a data processor, depending on what the circumstance is, yes, the commission can demand on your behalf that you be paid compensation by the company that breached your rights. The other thing is, even if this one is now my personal opinion, in a situation where the commission doesn't make such order and you feel that you deserve some sort of compensation for the breach, I think the act makes room for judicial reviews of courts of the orders made by the commission. So you can apply to the courts to review the decision of the commission and then ask for compensation to be paid to you. So yes, my answer to your question is yes. The data subject can get some compensation for the breach of his rights, provided that you have to prove that you suffered a loss or injury or harm, as the case may be, as a result of that violation. I hope I have answered your question. Thank you very much.
Okay, yes, that was, I think, yeah, it's the judicial review you mentioned is provided for under section 50 of the Act, and it provides that any data subject who has complained about a breach and who is not satisfied with the commission can apply for judicial review. It also allows for the data subject to ask for civil remedies for damages from the data processor or the controller. So the party who sued Fidelity Bank can, if it's not satisfied with, the compensation or the order made by the commission, he can go for a judicial review for the courts to review the order made. Okay, for Mr. Kelechi, we have one question for you. Please, who are data processors and controllers, and what are their legal obligations?
Sorry, say that again.
Said, who are data processors and controllers, and what are their legal obligations?
Okay. In a nutshell, a data controller is the party that decides the purpose for which the personal data will be processed. So if you're, let me give you a practical example that will help you to understand it better. If you go to the bank, you want to open an account, right? The bank decides the information they need from you and the purpose for which they need that information. So the bank in this circumstance will act as the controller. Now, the bank can also act as a processor if they are the ones using that information to provide a service to you. Now, if the bank is not the one that will provide that service to you, maybe they want to provide, they are engaging some other person to provide a service to you, then that other party becomes the data processor in that circumstance. So the bank, the controller decides the purpose for which the personal data is going to be used, processed. And then the processor is the party that processes the data. That is the party that uses the data to provide the service to you. So I don't know if that helps. It's just the simplest way to describe it. But you can read up and then have a holistic understanding of it. Yeah. Yeah. Thank you.
Okay, Rini, I think we won't be able to present anymore, so we'll give the floor to her to just continue from her end. For a brief moment, and we ask a couple of questions. Miss Winnie, can you hear me?
Hi, yes, I can hear you. Sorry, I dropped off the call. I was answering the question on standard contractual clauses. So I was saying these are mainly pre-approved by the regulator. So within EU, it's pre-approved by the European Commission, and it's specific. So there's standard contractual clauses for controller to controller relationships, but there's also standard contractual clauses for controller to processors, and now this governs transfer of data to a third country. So they have specific data protection clauses that the entity that is going to receive this data, so the receiving country or the receiving organization in the third country must comply to the requirements under this standard contractual clauses. I don't know if that properly answers that question, but I can share a sample of standard contractual clauses. Then you can look at it just to see if you can make sense out of it. It's a very clear document. You can easily just incorporate it. What I've seen in practice is companies have their own data transfer agreements, but they also incorporate some sections that are predefined in the standard contractual clauses, especially if a country where standard contractual clauses are not defined as a transfer mechanism in your country. So you can still incorporate the same for your transfer. Yeah, then we can now look at transfer impact assessments. And Chema, are you able to project?
I want to interact with them on the chat box, so I'm not be able to share my screen. You can just speak from your end and we'll share the slides to them.
Okay,
after.
that's fine. That's okay. So for transfer impact assessments, this almost similar to data protection impact assessments that are done for high risk processing activities, depending on what those are in your specific circumstance or in your country. So for transfer impact assessments, why they're important is they help in assessing legal compliance issues, such as adequacy frameworks that are required under different data protection laws. They also help in risk identification and mitigation from the transfer, and also they protect data subject rights and informs the basis of your communication to them. And they also help in mitigating litigation risk from non-compliance you can look at the Schrems decision that I mentioned earlier. So on how to do a transfer impact assessment, the first place to start is to assess the data protection law and enforcement practices in the destination country. So for example, does the country where you're transferring this data to have a data protection law that has equivalent provisions to the one that you have in your country? Then if they do have that particular regulation, then how is it enforced? Do they have a supervisory authority that can enforce that particular regulation? And what is the extent of, say, government surveillance? What can they access? What can't they access? And what are the guardrails that have been put in place to ensure that government does not have unfettered access to the data? Then you need to determine whether the foreign jurisdiction offers equivalent protections as those within a specific data protection law. For example, does the law in that country have data subject rights, and what are those data subject rights, and do they equally protect the individuals in your country in the event that their data is breached, maybe it is unlawfully accessed? Then you also need to evaluate whether there is an adequacy decision that has been given by your data protection authority. So if it's within EU, is there an adequacy decision for that country? If it's within Kenya, for now, we don't have any adequacy decisions that the data commissioner has issued. For Nigeria, I'm not so sure. Maybe someone from there can go into details on that. Then the other thing is you need to examine the transparency and oversight mechanisms that are in place for government access to that data. So this is a point that I have already mentioned. Then also look at the recipient organization or countries' security measures. For example, are they encrypting that data once it's in their custody? So this is data at rest. Is it being encrypted? What are the access control matrices that are in place? Who within the organization can have access to this data? Are all the employees trained on how to handle personal data in case of a breach? Is there an incident response plan? And how is this activated? Then you also need to look at the technical safeguards that you as an entity have implemented to ensure that when you're transmitting this data, it is also not possible for someone to intercept it. So there was a discussion on man-in-the-middle attacks. So this is one of the things that you need to look out for to ensure that no one else can intercept this data. Then look at all the possible risks to this transfer. So I mentioned some of the risks, including an equivalent data protection law, security measures implemented, government access, surveillance. Then you also need to keep a record of this assessment, because this will help you when maybe you want to report to the data protection commissioner, or they come and do an audit on your specific transfer. For instance, in Kenya, if you're transferring personal data to another country, based on, if you're transferring personal data outside Kenya and there's no adequacy decision, you're supposed to record certain things, including the time when the transfer is happening, who is the recipient of that data, what are the safeguards that you've put in place. So these are records that you need to always have in place to ensure you're actually complying with the accountability requirements and the data protection laws in your country. Yes, and that brings me to the end of my presentation. So in conclusion, what I can just say is it is important to be aware of your specific local context with regards to transfer of personal data. So what does your law say when you want to transfer personal data, and how is your business ensuring that you're complying with the same? And in the event that maybe it is not clear to you on how you need to transfer that data, then there's always the option of reaching out to your regulator for them to give you guidance. At least within the Kenyan context, the Office of the Data Protection Commissioner is always responsive in terms of giving you guidance on how best you can approach cross-border data transfer issues. So it is important to communicate with them. And this will also just help you in ensuring business continuity. Yeah.
Okay, thank you very much. Thank you very much, Winnie. Okay, I have a couple of questions from my end. So, the first question, how can organizations implement incident response and breach handling measures? Like, what are the measures that for incident response and breach handling, and how can organizations implement them?
Is this a question for me, Choma?
Yeah, oh, yes, yes, sorry.
Okay. So for incidents response, how I approach it is to ensure that as an organization, you have an incidents response plan. So within your incidents response plan, you need to define who handles what in terms of an incident. So who are your stakeholders? Is it the IT department? Is it legal? Is it compliance, communications, all that? Because they form part of the whole response and notification to the regulator. So you need to be specific on who are your stakeholders. Then you also need to do tabletop exercises just to test your response plan to ensure that it is actually effective. So in responding now, say a breach has happened, in responding, what I use is CARE. So CARE. So for CARE is the first, the C says that you need to conduct an assessment on the extent of the particular breach. Then under A, you need to look at how many people have been affected, what is the type of data that has been affected. You also need to contain the breach. So if it is a particular system that has been affected, you need to take it offline to ensure that the same does not spread to the other systems. You also need to report to the Data Protection Commissioner in your specific country, and you also need to do that within the specified timelines. If it's in Kenya or in EU, you need to notify them within 72 hours of the breach happening. Then also, if you have processors and the breach has taken place from the processor's perspective, then they need to notify you either as soon as possible or in Kenya, it's within 48 hours. So they need to notify you within 48 hours so that you can also make that report to the regulator on time. Then once now you properly contained the breach, you know why it happened, and you put in place mitigation measures, you need to update your incidents response plan and test it again to ensure that everything is well captured.
Okay, that is very, very insightful. I just shared my experience so that anybody that's didn't follow your presentation can just briefly see. Okay, and my second question. So, what are the steps involved in conducting a data protection compliance audit? And Winnie, can you hear me?
Yes, I can hear you.
Yeah, I said, what are the steps that are involved in conducting a data protection compliance audit, like an audit? What steps do you take? So maybe to audit a system that you would want to transfer data to, or for data transfer, cross-border transfers of content. What are the steps to conduct an audit?
An audit for a system that you're transferring data. I'm
Yeah,
not sure I
and
properly understand.
So it says here, what are the steps for conducting a data protection compliance audit? Maybe if this to check if the system is compliant with
Oh, okay.
Regulatory measures, yes.
So for me, I use the data protection impact assessment. So that is what I use when I'm trying to see if the system that you're going to use to transfer data, or basically the system that you're using to process data provides the adequate level of safeguards. So for instance, if you're transferring sensitive personal data, you'll do a DPIA. on the whole processing activities. So for a DPIA, you need to first assess what is the type of data that you're handling and do you need to do a DPIA. Then you need to look at the necessity and the proportionality. Is there a way that you can maybe transfer this data without is there a way that you can transfer that data and still maintain its security? For example, if you don't need to transfer the whole data set, or can you anonymize, for instance, can you anonymize that data? And is the effort that you're trying to put in place proportionate? For example, do you have data centers within your country that offer you the same level of protection or an even higher level of protection than, say, AWS or any of the other servers that you have wherever within the world? So you need to look at that. You need to look at how, as an organization, you're going to ensure that the data protection principles are being adhered to when you're transferring that data. You also need to look at the transferring entity. Do they have adequate safeguards that they have put in place? Do they have encryption? They have pseudonymization? Are their employees trained? Are they going to use sub-processors? And what is the level of access to this data for the sub-processors? And is there a contract that governs the relationship between yourselves and them? You also need to look at data subject rights. How are you enforcing data subject rights for the specific transfer? Can they complain to the regulator if there's a breach? Can they reach out to you? How can they reach out to you? Then the other thing you also need to ensure is your management team has signed off on the DPIA. So once you've identified the risks, you've put in the mitigation measures, you need to look at your management team for them to sign off on that. Because if they don't sign off on the DPIA and you're a DPO and something happens, for maybe that data is breached or there's an enforcement decision against the organization, this will fall squarely on your shoulder. So it's important to make sure there's a sign off. Then if there's the obligation to report to the regulator, you need to report that within the stipulated timelines. If it's in Kenya, you need to report within 60 days before the specific project. So if the project is transfer of data, you need to notify ODPC within 60 days before you transfer that data for them to give you their input on whether you can continue with the transfer or what are the additional safeguards that you can put in place.
Okay, thank you very much. I think I was able to note down like everything you said about 12. Okay, let me just give a brief rundown to see. Okay, so you mentioned for an audit, you consider the type of data that is being, handled, if it's in sensitive personal information or or the likes. Then you said the access to the type of data that's being handled. Then you also mentioned necessity and proportionality. Is it necessary? Is this necessary to like transfer this data? Then you said, can the data be transferred? And if it can be transferred, would it still maintain its security? Or would you have to just transfer only part of the data? Then you also mentioned, can it be anonymized? You also mentioned, do the data outfits, would you, for example, if someone is trying to transfer to, a security system that's outside that, is there a better security outfit in their jurisdiction that can offer the same service to them? Then you also, for the sixth one, you also mentioned to ensure the data protection principles are adhered to. Then the seventh one, do the organizations have adequate security measures? The eighth, you said there has to be a contract that governs it, that is a data transfer agreement. Then you also mentioned data subject rights and if they are being protected, and what are the measures that the data subjects have where there is a breach of their data. Then you also said if the organization's management team has signed off on the transfer or the DPIA, Then you also looked at the obligation to report to the regulatory authorities, that is to notify them where there is going to be a transfer, where you also mentioned that I think you said Kenya has about 60 or 62 days for to report where there is a transfer, then the regulator for the transfer. I don't know if that is if I got it correctly.
Yes, that's correct.
All right. Okay, for the last and final question for today, you said when does an organization need a DPIA? Because you mentioned you usually need a DPIA when it depends on the kind of data you're sharing. So when does the organization need a DPIA?
Okay, so an organization will need a DPIA where first you're processing sensitive personal data, you'll need to do a DPIA. If you're implementing or you're going to use new technologies, you also need to do a DPIA. So for example, if you're going to use AI or you're integrating systems, you'll need to do a DPIA. You also need to do a DPIA where you're going to be merging data sets. So for example, if you're conducting a customer survey and you already have some data on specific customers, but you decide to look at maybe their social media pages, what are their preferences. So you gather additional data from other sources. You need to do a DPIA for that particular processing activity. Also, if you're using monitoring technologies of large accessible public area, you need to do a DPIA. So this is mainly specific to CCTVs. So if you're using CCTVs, you need to do a DPIA. Of the other instance that you need to do a DPIA. Yeah, that's pretty much it.
Okay.
But then
Okay, so
the regulators in the specific countries can give more guidelines on what
Okay.
else you need to do a DPIA for.
Okay, that has been very mentioned when you need a DPIA. So context, the DPIA is a data data protection impact assessment. So basically it's saying that you need a DPIA when you're dealing with sensitive personal information concerning information you can use to identify the data subject. When you're dealing with new technologies or emerging technologies, like she mentioned, AI, then integrating systems, or when additional data is gathered from other sources, or when there are monitoring services that are being used. So I think that was the last question from me. I don't know if anybody has any other question from Minnie. Okay, someone in the chat box also said that for when conducting a DPIA, the law also requires that you have a data protection officer, which is very true, because that is the person that's going to be the liaison between the organization and the regulatory body as well as the data subject, someone who is well versed in data protection and privacy. So I think we've come to the end of this webinar. We're so sorry we took time. I think 30 minutes out of the 2 hours we already scheduled. But it has been very insightful. I can say so for myself, and I'm sure I'm speaking on behalf of everyone that it has been very. Mr. J, thank you. So I can say for everyone that it has been very insightful. I want to say a very big thank you to all the speakers. You did justice to the topic and I learned a lot. In fact, I took so many notes. And I know that this has been very helpful to everyone, even to myself, that participated in this webinar. Okay. Just to be clear, we're so sorry that we could not adequately present the slides, but the slides will be shared to everyone through their email address after this webinar. And I'd like to, officially end this webinar and join us this time next month for another insightful session. Thank you very much and have a nice day. Okay, someone said, Mr. Kelechi, you kindly drop your email address like you said. Okay. And we can connect with us. We have a briefly to say we have a LinkedIn page, so you can rise and you see a page and we have tapped the speakers to post there, so you can just connect to them and reach out to them for any further information you might need. All right, thank you very much and have a lovely rest of your day.